Friday. My Lord, I will refer you to the ruling that you delivered this morning, where has been expressed, my Lord, that this court would provide a remedy at whatever time is moved appropriate. You've also, my Lord, stated that it will not be right for a party to anticipate or engage this court in speculation. To therefore, my Lord, seek a mention on Friday, my Lord, based on the same reasons of speculation and anticipation, my Lord, would be contemptuous, my Lord, of the ruling that you have delivered. My Lord, we had indicated before you yesterday that we have other about 23 matters related to the consolidated petitions before you. My Lord, we've hardly had time to, my Lord, engage in those matters. The petitioners before you, my Lord, have had their share of the judicial time.
Mr. Mlima, if we were to know what we are going to say, we are going to limit the time because the applicants have not used the amount of time you have used in response.
Thank you. My Lord, therefore, I would request that you do not give them, my Lord, that request for Friday. That, my Lord, you allow this matter then to take its normal cue. And that, my Lord, we will be available to come back before you any other date, my Lord, next week, for a mention. I should note, my Lord, all our other colleagues are before the Senate. They are not here, my Lord. We do not have their diaries. We request, my Lord, that you decline that request to appear before you try. I thank you.
Thank you.
Lord, from your leadership, will be just 1 minute to respond to those issues. As regards the issue of amendment to the petition, Lord, at the time a petitioner is approaching the court for a remedy, we don't disclose essentially what the nature of the petition is. A party is free to file a case before the court and raise issues where the respondents will then have a chance to respond. So that in case an amended petition, your Lordship, is filed, the respondents will not be prejudiced in any way because they will have an opportunity to respond to the amended petition. So that even if there's a change of prayers or anything in the petition, then they will have an opportunity to respond to anything that could be introduced in the amended petition so that there is no harm in allowing that particular prayer. And we have had an experience with this, my Lord, in a matter that was starting to move. When parties sought to amend a petition, Mr. Milimo side post the amended petition on the basis that leave had not been granted. So to avoid all that, and noting that this is a matter that has very strict time constraints, we would think that it would be prudent that this court allow at this time that you can file an amended petition. On the second issue of the mention of the outcome is two. The deputy president can either be impeached or the charges before the Senate might be dropped so that they are not confirmed. So that it will also be important for the court's program to know what is the outcome of this particular matter that is of great public interest. The mention on Friday will therefore help in updating this honorable court on the outcome of that particular process before the Senate, so that we either seek direction for hearing of the petition or we update the court as we are hoping that the charges will be dropped, that these petitions have then been taken by them so that they don't continue holding the shares of the court. So that it is important that we don't spend a lot of time in getting direction resolution for these petitions that are pending before the court. That is why the mention is urgently needed so that we can address that issue conclusively. Thank you.
Yes, my Lord, my ladies. Yesterday when we were online, I heard Mr. Ndimo saying that the parties are bound by their agreement. And therefore, it cannot be had this morning to bar the same parties from amending their petition. My Lord, my lady, this court has powers and jurisdiction to guard itself from abuse by any party seeking amendment of its agreement. And therefore, the submissions by Mr. Ndimo are speculating that parties indeed intend to abuse the process by making or introducing matters that would render the petitions totally new. A lot of ladies have had Mr. Ndimo submit that advocates who are not present, they have no advantage of taking the directions that will be given. Every party that has been here has actually given an indication that they are holding it for certain people. Therefore, no party will be prejudiced by any direction that has been given by this court. In conclusion, Mr. Ndimo's opposition to the amendment of our petition is just bastard this matter.
What did you say? That word. It's just. What did you say? Flip? What's the spelling? Filibustering.
Yes.
To?
Filibustering the matter.
What does that word mean? What is the meaning of that word?
To stall the process.
Yes.
That's an easier way of saying it. Yes.
Delaying something without necessarily breaking the rules, what filibustering. My assistant is a definition of filibustering, but I had looked at it before deciding to use it. So that it's an opposition for opposition's sake. Nobody intends to abuse the process of this by amending. We'll add a paragraph or thereabout, and he knows what is like. Parties have submitted, depending on what will happen in the Senate. They given leave to amend their petition. So that does not amount to an abuse of process. That's what we want.
Thank you. Do you have any parties online who want to comment on this matter?
My Lord, if I may just make one remark, and this one is for the benefit of Mr. Ndimo. Last week on 11th of October, in Kerugoya, in petition number E014 of 2024, which is related to this subject, this issue arose before your brother, Justice Mwongo. And in a recent ruling, which you'll be getting a copy of today, Mr. Ndimo vehemently opposed a similar application for amendment, and the judge made a ruling where he allowed these kinds of amendments. And what the judge said is that the mutating nature of this process necessitates constant updating and amendments. So this is not one of those cases where facts exist and they don't change. They change every day. So that by The end of today, by the end of tomorrow, the facts will be totally different. So let us leave that room open, at least up to the conclusion of the Senate proceedings. Thank you, Madam.
My Lord, for the record, my then colleague will confirm. I was not in Korugoya. I don't know whether I'm a prominent beneficiary. You must withdraw that, my Lord. I was not in Korugoya.
Sorry, my Lord, Mr. Nyamode, his senior is the one who was leading the delegation.
Thank you.
My Lord, my lady, on the fact, my name is Ukola, for the 3rd, 4th, and 7th respondent. On our part, we thank you for your ruling this morning, and we thank you for allowing the 4th respondent to proceed with the constitutional process before it. On the applications made by counsel to the petitioners, we shall abide by the directions of this court.
Thank you. Do you have any parties, counsel online, who wish to comment on the application for leave to amend petitions? If there's none, I think you cannot amend petitions except by leave of court, and therefore the issue which we have raised, we need to consult on it and give an appropriate ruling. We'll therefore adjourn for 20 minutes.
That's a good one.